everybody. My name is Larissa and I'm an attorney here in Las Vegas, and I practice in the areas of estate planning, probate, and personal injury. I know why you guys are here today, and I'm so glad you're here with me to watch my webinar on estate planning and how to keep your family out of court and out of conflict. I will go through several topics today, but before we jump in, if you haven't already done so, I'd like you to download your workbook in the link underneath me speaking. Just to let you know a little bit about me, I'm a mom, I'm a wife, and I'm a lawyer, and I've been doing estate planning for about 7 years now. I want you guys to make sure you print out the workbook that's in the link in your reminder emails and the link displayed in the chat box and below my screen. You will use this workbook as you go along to keep you engaged and to remind you of the important things we discussed after the webinar. I want to remind you guys that the best way to learn is to be in a silent place where you're either alone or with your spouse, to turn off your cell phones, and know that you deserve this time to yourself to learn the legal basics on how to protect your family and your finances and keep your family out of court and out of conflict. I want you to know that your guys' time is very well spent on this webinar with me, as you will be learning the legal basics of estate planning and how to keep your family out of court and out of conflict if something happens to you or the ones that you love. And just as a little gift from me to you, I will be offering a complimentary one-on-one session with me and $250 off of any planning package. The details on the free gifts that you're getting at the end of the webinar will be at the very end, so stay tuned till the end. So before we dig into the meat of the webinar, I'd like to know who knows what estate planning is or who has a plan done. You can simply type into the chat box your answers. If you do not have an estate plan, which most Americans do not, you're not alone. Up to 60% of Americans over the age of 18 do not have an estate plan. Most people who do not have an estate plan do not have an estate plan for the following reasons. One, they believe that creating an estate plan will either hasten their death or incapacity. And I want to bust this myth. Creating an estate plan, in my experience, has never hastened anybody's death or incapacity. Myth number 2 is that estate planning is expensive. That myth is also not true. With my planning, you choose your fee that is affordable, and we come up with a plan that's right for your family. Myth number 3 is that people think they are not old enough or not wealthy enough. But the truth is, if you have anything to leave behind when you pass away and people that you love, you do need to have an estate plan documenting exactly what you want to leave to who and what your wishes are if you become incapacitated and cannot make decisions for yourself. I want to let you know that you are in the right place, even if you do have an estate plan, if you create it online with Rocket Lawyer, LegalZoom, or any one of the estate planning websites where you fill in the blanks, or if you have an estate plan that you have not reviewed in the last 3 to 5 years and is incomplete regarding your new family dynamics and appointing guardians for any minor children that you have. You are at the right place if you have anybody and anything that you want to protect if you become incapacitated or if you pass away. The truth is, estate planning is what you do for the people that you love the most. Because when that time comes that you're no longer around or you're no longer able to make your own decisions, somebody is going to have to clean up that mess. And your family will know how much you cared about them by the time, effort, and energy that you put into preparing things for them and making it easy for them when you are no longer able to manage your affairs. So as I mentioned, my name is Larissa and I'm an attorney. I've practiced law in Nevada for 10 years, and I'm also licensed to practice law in New York State. Some of my awards and accolades include being nominated for the Women of Distinction Award and being featured on CNN, ESPN, and other national news outlets for my involvement in litigated cases. Not to mention my involvement in several celebrity estate planning matters and estate litigation cases. I became an estate planning attorney early on in my career, where I handled a wrongful death case where a 2-year-old little girl was in the backseat of a car and her parents were in the front seat. Unfortunately, her parents were killed, and neither parent had a plan in place to protect their assets or appoint guardians for their 2-year-old child. Over the next several years, contentious litigation ensued over the guardianship for the little 2-year-old girl. All of these problems and legal fees could have been avoided if her parents had basic estate planning in place. You see, if her parents knew what you guys will know at the end of this webinar, they would have had planning done in order to protect that little girl and the money that they left behind for her. I understand that what happens sometimes with most people is that planning for the future is something that we know we should do, but often don't get around to doing it. Because the truth is, our lives are busy. We have work, we have children, we have family, we have a ton of things that we need to handle immediately, and planning for the future is sometimes just not at the top of our priorities list. Because of that story with the 2-year-old little girl, I've made it my mission to educate as many families as I can on the importance of estate planning, and made it my goal to help as many families in Las Vegas, Henderson, and North Las Vegas get proper and comprehensive, customized estate plans in place. On a personal note, I also do estate planning because I'm a mother. I have an 18-month-old and a 3.5-year-old. And I know if something were to happen to me, I'd want my children to be well taken care of and everything to be put in place legally. And that's why I've created my own estate plan. I want to share my mission with as many parents and families as I can to avoid the lengthy, confusing, and troubling probate and guardianship court process. So what is estate planning exactly? I hate that term because it's so legalese and it sounds so pretentious. But estate planning, in a nutshell, is putting a legally documented plan into place that states your wishes if you become incapacitated or when you pass away. It's best to think of estate planning as a plan for life, not death, because once you've legally documented all your most important decisions and you've made them legally enforceable, you can live with less stress knowing that everybody that you left behind that you love is going to be well cared for. By making your estate plan now, you are relieving a huge burden off of the people who will be left behind to clean up a mess when you either become incapacitated or pass away. Because once you've created a customized estate plan with me, your family can bypass guardianship court and probate court. Most people think that they cannot afford to pay an attorney to prepare an estate plan for them. But the truth is, estate planning and being proactive is a lot cheaper than having to drag your family through guardianship court or probate court when you pass away. So let's look at Nevada's plan for you if you do not have a legally documented estate plan that is enforceable. First, if you become incapacitated, your family will have to go through guardianship court. And that is even the case if you are married. Just because you're married to somebody does not mean you can automatically make their decisions for them. In many cases, I have had to create a guardianship case for spouses who have not created estate planning documents. And unfortunately, when one spouse becomes incapacitated, a guardianship court action is required. These cases are public and they cost thousands of dollars. Not to mention that guardianship court stays in your life until the protected person who's incapacitated either regains capacity or passes away. This is not a situation that you want to leave your family in. If you pass away and you do not leave an estate plan, you are guaranteeing that your family will end up in court and conflict and probate court. So what is probate court and what is the probate process? So let's look at Nevada's plan if you pass away and you do not have an estate plan. First, it involves probate court. Your assets are going to be frozen at the moment of your death, and your family will no longer have access to any accounts that bear your name solely. Secondly, a probate court action has to be started. And this takes a long time, not to mention it's very expensive. You have no control over who your assets will go to if you do not create a valid estate plan. Instead, the state of Nevada has created statutes that are called Intestate Statutes that say who your property will go to when you die if you do not leave a valid will. There are many steps throughout the probate process with built-in delays along the way. And the fees in probate are very expensive. Those fees include attorney's fees, filing fees, bond fees, appraiser's fees, and other fees built in along the way. The other problems with probate is that it's a lengthy process and it's public, meaning people will know how you passed away, who your heirs are, and what you leave behind. Furthermore, creditors peruse the probate court filings to find out who is inheriting what and to prey on people who they believe are vulnerable and inheriting a lot of money. The worst thing about probate is the time that it takes and the fact that if you do leave minor children behind with an inheritance, they will not get their inheritance until they're 18. The money will be locked up in guardianship court, and anything that you leave to them that is not in a trust will distribute at the age of 18 with no oversight or direction. Okay guys, think about it. One of the worst things that happen when a person passes away and they do not have an estate plan that was created with a qualified attorney like myself is that many assets get lost. Think about it. Did your family know where your bank is? Do they know what your life insurance policies are? Do they know where your 401ks are administered or your IRAs? Many people keep this information secret, and the moment that they become incapacitated or pass away, people lose track of everything that a person owns, and it becomes lost in the State Department of Unclaimed Property. Believe it or not, there is a way to avoid your family having to go through probate court or guardianship court when you pass away, and a way to keep your family out of conflict. The best way to do this is with a revocable living trust. A revocable living trust is essentially an entity that you create, that you transfer your assets into while you're alive, and while you're alive and have capacity, you manage those assets as you wish. You could buy, sell, trade, or completely terminate your trust. Once you transfer your assets into your trust and your trust is fully funded, your assets will avoid probate court and guardianship court because these assets are no longer in your name and in the name of your trust. What protects you from your incapacity or death is naming a successor trustee to come in and manage your assets in your trust as you leave in the directions of your trust document, making sure that those funds are used for your well-being if you're incapacitated, or leaving funds to your family in the ages and stages that you choose, following all the directions that you've left behind for how your assets should be distributed when you are incapacitated or pass away. Revocable living trusts are not hard to set up. It just involves some legal paperwork that a qualified attorney such as myself prepares. Furthermore, it's not a long process. You meet with me and we go through a family wealth planning session to determine what structure of your trust is appropriate as it relates to your assets and your family dynamics. And by the way that I do my trust ensure that none of your assets get lost to the State Department of Unclaimed Property. Now, what I want to talk about now are some ways that people think that they can avoid getting proper estate planning done by an attorney. Many people think that owning property as joint tenants is a way to avoid probate court. Well, the truth is, when a person dies and an asset is owned jointly, that asset will automatically transfer to the living heir or joint owner. However, this process does not protect against probate court when both individuals who own the asset pass away. It also does not protect against creditors of either joint owner from attaching onto that property. So you want to be very careful about who you own property with as a joint owner, because creditors can come after the other owner's share of the property. Many people think that they can avoid probate court by designating a beneficiary. True, designating a beneficiary will avoid probate court. However, not all assets will allow you to designate a beneficiary. Furthermore, if you have minor children, You do not want to designate them as beneficiaries on any assets, as minors cannot own property, and you are guaranteeing that your child's inheritance will end up in guardianship court, assessing fees and costs for attorneys, and also ensuring that those assets will distribute directly to your minor child at the age of 18 with no oversight or direction. Another pitfall that I see people fall into is designating a beneficiary to be the custodian of funds if they have minor children. This is problematic because if you designate an individual as a beneficiary and have some written agreement or verbal agreement with them about how to spend the money, it is not legally enforceable as long as that person is named as the beneficiary of the funds. What that means is as soon as you put somebody's name on that line for the beneficiary designation, they are the ultimate owner of the funds legally. They have no legal obligation to share that money with anybody, and furthermore, their creditors can attach to those funds once that money goes into their account. I do not recommend beneficiary designations for any minor children unless it's to your trust, and I do not recommend beneficiary designations to anybody that you do not think can handle a large amount of money at one time. A lot of people think that just having a will is sufficient to having a full estate plan. The truth is that a will go through probate court if there are any assets owned solely in the deceased person's name when they pass away. Furthermore, having a will is only effective when you die. So having a full estate plan would include having documents prepared that provide for your incapacity. Let's face it, we don't know when we'll be in a car accident, and a lot of people think that incapacity only relates to when you're old and get dementia. But there have been plenty of cases in my career that I've seen where people have been young and been incapacitated and not had the legal documentation needed to keep their family out of court and out of conflict. The last problem that I see with people's misconceptions about estate planning is that getting online forms or any attorney to do their estate plan will suffice for a comprehensive estate plan. The truth is, online document preparation is not a substitution for having an attorney that's qualified create a comprehensive and customized estate plan. Lastly, any old lawyer that you find can draft up a basic will. However, you do want to hire an attorney that has experience with guardianship and probate court like myself, so that they know how to craft the documents to provide for all contingencies and keep your family out of conflict no matter what. If anything that I've said during this webinar has you thinking, what would happen to my family if something were to happen to me? Or would my money end up in the State Department of Unclaimed Property? Or would your family end up in conflict if you left no documentation behind? I want to offer you a complimentary family wealth planning session. This session is a $750 value, but because you are here getting educated and took the time to watch this webinar, I want to offer you this session at no cost. During the family wealth planning session, you will tell me about your family dynamics and your assets. I will evaluate everything that you own and determine how it's owned, and you will tell me about your family dynamics. You will ask me what would happen to XYZ asset if I were to pass away, or what would happen to my children if I would become incapacitated. I want to give you the answers to all your questions in the complimentary family wealth planning session. In order to have this session with me, you're required to do a little bit of homework where you tell me about all your assets and your family dynamics. At that session, we'll have a dialogue where you can ask me anything you want about the probate court and guardianship court process, and you can ask me what would happen to XYZ asset if something were to happen to me. At that session, I will give you all the answers and give it to you straight. You see, I've done a lot of probate and guardianship work, and I know how judges look at scenarios. When you feel like planning is appropriate with me, we will customize a comprehensive estate plan that will keep your family out of court and out of conflict, and customize the plan to make sure that none of your assets end up in the State Department of Unclaimed Property. When you choose to get your estate planning done with me, I will ensure that you make empowered and informed decisions. And you will walk away feeling stress-free, knowing that you've put everything into place and done it the right way so that everything that you love is protected when you are no longer able to make decisions or manage your assets, either due to disability, incapacity, or passing away. I understand that most people procrastinate, and that's the reason why things don't get done. But if you book your planning session with me right after this webinar, I'm going to give you an extra $250 off of any plan we create together. And I call this my golden ticket. So the way to redeem your golden ticket is to book a planning session with me and do your homework. I look forward to speaking with you and helping your family, and I will put up my contact information at the end of this webinar for you to get in touch with me directly, or you can click on the link and schedule directly with me for your family wealth planning session. I thank you so much for being here with me. I know you learned a lot, and I hope I've done my job of educating as many people as I can to get proper plans in place to make sure that their family does not end up in court and conflict, and no little girl ends up like that 2-year-old that I had a case with in the beginning of my career, which inspired me to be an estate planning attorney. Until next time, have an awesome day.